Welcome to Newsbreak. Let's now talk about the sedition law. You see, what has happened today is that the Supreme Court has referred the sedition law to a larger bench. The Supreme Court referred the pleas challenging the sedition law to a constitution bench. The Chief Justice of India said reference to larger 5-judge bench is needed on an issue as crucial as sedition. The Supreme Court rejected the centre's request to defer hearing on the sedition law challenge. The centre's request to defer the hearing was due to the new bill to replace the IPC. We'll get to that in just a short moment. The Chief Justice said that no effect on pending cases under sedition law despite the new law, and that is why this matter will continue to go. The Chief Justice also said that the new panel law can only apply prospectively, that is, from here on. Now, what exactly is the sedition law? Section 124A of the Indian Penal Code as of this moment. The law lays down punishment for sedition. It deals with offences against the state. It could be used on those writing, speaking or rebelling against the state. It was brought in by the Britishers. Possible life imprisonment for those who are found guilty. It was kept on temporary hold after the top court order in May 2022. The Supreme Court had given centre time to relook at the sedition law. The Supreme Court said law was misused by centre to quash dissent. Now, obviously, there is in the new proposed law, which is called the Bharatiya Nyaya Sanhita bill, which is right now, the reason why I say proposed is because it's gone to a House panel in Parliament. It scraps the concept of sedition, but it does something else. What does it do? And that's why it starts a debate whether sedition law has been repealed or strengthened. The proposed Bharatiya Nyaya Sanhita Bill 2023 says sedition word is not included in the new bill. Section 124A, though, has been replaced with Section 150. What is this section? It says anyone endangering the sovereignty and unity of India. Currently, it is punishable from 7 years to life imprisonment. In the new bill, the punishment is from 3 years to life imprisonment. Now, in the context of the colonial sedition law, there was a point of reference called the 1962 Kedarnath judgment. Now, the case that redefined the sedition law, because up until that moment, anything said against the state or the government was considered sedition. According to this landmark Supreme Court judgment called the Kedarnath Singh judgment versus the state of Bihar, the judgment upheld the constitutionality of the sedition law. The 5-judge bench toned down the sedition law, saying that the criticism of government action has to be within reasonable limits. Comment on government action consistent with right to freedom of speech. Law is applicable only to words with pernicious tendency. Law is applicable to words with intent of creating public disorder, and also public disorder was defined as, action resulting into violence. So any call to arms or violence would have fallen into the purview of sedition. But did the governments apply the 1962 Kedarnath judgment consecutively? I think that was put to a debate in the Supreme Court. So in this context now, sedition law, the existing sedition law, not the new one which has been proposed, has been put under review by the Supreme Court, which has referred it to a larger bench. What are the implications? Let's quickly discuss. We've got Vineet Dhanda, is an advocate in the Supreme Court, former Assistant Solicitor General of India, and Shadan Farasat, advocate in the Supreme Court, former Additional Standing Counsel, Civil Matters for the Delhi government in the Delhi High Court. Thank you very much to the two of you for joining us. Mr. Dhanda, I would like to begin with you first and ask a very basic and pertinent question. At a time when the central government appealed also in the Supreme Court, that we've got a new law in place, it is under discussion, it's in a proposal stage. That's why to put the existing sedition law in review may not be required. Where are we vis-a-vis sedition right now?
See, as far as presently, after Kedarnath judgment and after 2022 intervention by Honorable Supreme Court, basic thing which is being considered to put sedition is this, that any act which endangers public order and incites violence and endangers the sovereignty of our country, then that person can be booked. But the present law which is being brought under section 150 in new proposed bill, that covers a very comprehensive thing. It covers the words either spoken or written, by signs, visible representation, by electronic communication, or by financial means. So comprehensive act against the country is being covered in the new proposed decision. And this will cover very basic thing through which the endangerment to public order is made. Today, the world has advanced, and in advanced stages, the new means, financial means, electronic means are used to endanger the public order, to create disharmony and other things. So the new proposition covers everything in that. And the punishment which has been increased from 3 years to 7 years will make it more deterrent. Such acts will become deterrent in future. And the most important part in this is that governments will not be able to misuse it. There was a dissatisfaction that if you are dissatisfied with the government and you make any speech or expression against the government, then you will be fixed for sedition. That has been taken care of by the government at present. Misuse of sedition law will not happen. Only the acts and acts which will endanger the peace of the country, that will be taken care of.
Okay.
And that's a very positive step by the government of India.
Shadan Farasad, is that so?
No, so two things, Sanket. Firstly, I think insofar as 124A is concerned, today there was an attempt by the government of India and the court to say that, listen, because this proposed legislation is in the, in the process, the court should not do anything about examining 124A. So that has been squarely rejected for a whole host of reasons, because existing prosecutions are going to be dealt with under 124A itself, and there are many prosecutions, especially many started by this central government, approved, etc., by this and police forces which are directly reporting to the government. So the court was of the clear view that in whatever new legislation may happen, that does not impact what we are testing today, which is 124A, that is sedition law as it exists on the books today. So that argument was, there was a lot of attempt, multiple by the AG, by the Solicitor General, but the court rejected that. And in my view, that was the correct approach, because existing prosecutions are a problem. Number one. Number two, we come to the comparison. Now, insofar as comparison between 124A and 150 of the proposed new legislation is concerned, it's effectively old wine in the new bottle. It's the same thing, just named differently. Like, look at 150. It says by use of financial means, okay, that's a fresh addition, no problem. Or otherwise excites or attempts to excite secession or armed rebellion or subversive activities. Now, what is subversive activities? Anything can be subversive activity. Has it been defined anywhere? What is subversive activity? I don't like the government of the day I'm criticizing, that is framed as subversive activity. So in my view, it's actually far worse. At least Kedarnath limited 124A to certain situations, that judicially it was restricted. What you are introducing now is a new provision which is completely untethered. So therefore, this provision, effectively this whole thing that, oh, we have now done away with sedition and this new provision is great. Look at it, read the text. The text itself is so broad. It's open to misuse much more than even 124A post Kedarnath. So I don't buy that argument at all. I think the court also saw through it. That in fact, one of the arguments by the petitioners today was that, listen, if you determine what is constitutionally permissible, that will also have an impact on the proposed legislation. If the court were to come with, say, a decision in some reasonable time that these kind of provisions or similar provisions are not constitutionally permissible and defines the constitutional limit, then even a proposal like 150, the parliament should not be able to pass it then, because constitutionally it will become impermissible. So I think this whole distinction is really a farce. It's nothing more than that. It's the same old wine in a new bottle.
Mr. Dhanda, would you quickly like to respond to these fears?
I disagree with my learned brother in this.
There's an allegation and there is a fear, not allegation, fear that there is far more broad stroking in the new proposed section 150 than the existing sedition law, 124A.
I disagree with my brother on one thing, sir. Dissatisfaction with the government, that is a very important part which has been removed. We have to consider that. That's a positive step. Secondly, if my learned brother has read it, I'll read it for you, sir. By electronic communication or by use of financial means or otherwise excites or attempts to excite secession or armed rebellion or subversive activities or encourages feelings of separatist activities and endangers sovereignty of or unity and integrity of India. For this government, the sovereignty and the basic concept of Bharat, that is important, sir. And dissatisfaction with the government is not a part of this section 150, which was being misused by the governments previously, and that is why the intervention of Honorable Supreme Court happened, and sedition was toned down to public disorder. But this covers many aspects, because today freedom of speech and expression is being taken for granted, and on the social media and other mediums, total unrest is spread by one statement of a person. I'll give you an example. A very big political leader of an opposition party gives a statement that Citizenship Amendment Act is going to throw all the Muslims out of the country. So such statements will be taken care of by this section. It doesn't talk about the dissatisfaction. You can use your freedom of speech and expression to criticize the government. You will not be fixed for sedition. Rather, word sedition has gone out. Any act against the sovereignty of our country will be taken care of strictly, because now you will be punished if you do anything wrong against the sovereignty of our country.
I think the example that you gave itself would be subjected to, I would say, some amount of criticism, whether this falls in the ambit of questioning the sovereignty or not. See, it's the, I think this is the reason why this has gone to a House panel for further fine-tuning and deliberation. Thank you very much for joining us, Mr. Dhanda as well as Shadhan Farasat. I have Mr. Faizan Mustafa also. He's a constitutional expert. Faizan Sahab, how do you view the events in the Supreme Court on this on the sedition law, that the 1962 Kedarnath judgment will also be put to a review?
No, this is on the expected lines, because since if you look at the Law Commission report and the way 124A was used, we were not even following Kedarnath. Now, Kedarnath was saying that unless there is violence coupled with the words, the offense of the sedition is not made out. So as you know that the former Chief Justice Ramanna had put it under suspension for a while, and the government then had agreed to it. Then the Law Commission went against the Supreme Court and said that we must retain it to preserve and protect the unity and integrity of the country. And today what the Chief Justice of India was saying, that Kedarnath itself was on a very narrow ground, because it looked at sedition only from the perspective of freedom of speech and expression, that mere words are not to be punished. But Chief Justice said that subsequent to Kedarnath, Supreme Court itself understands fundamental rights not in silos, but they say that Article 14 and 19 and 21 are to be read together. And therefore, sedition is no more just an issue of freedom of speech. It is also an issue of right against arbitrariness, right against personal liberty and human dignity. The entire wider ambit of Article 21, as you know that in number of cases, Supreme Court has widened the whole idea of right to life and personal liberty and incorporated virtually the American doctrine of due process of law. So since it was a 3-judge bench, it was bound by Kedarnath, which was a 5-judge bench. The petitioner's lawyer said that why don't you straight away refer it to the 7-judge bench, to which Chief Justice did not agree. So the matter will now go to a 5-judge bench, and a 5-judge bench may say that our judgment in Kedarnath is no more valid. and they may differ from that, or in all likelihood, a 5-judge bench may itself refer the matter to the 7-judge bench. So I see the developments on the expected lines, except you know that in between there has been an introduction of Bharatiya Nyaya Sanhita, which is going to replace Indian Penal Code. And in the draft penal code as introduced, you do not have any offense with the name of sedition, even though something more serious and more wider is there in what has now become Section 150.
Mr. Faizan Mustafa, you see, this new law which has been proposed, which is in study by a parliament panel, it proposes to scrap the word sedition but replace it with something else. So in a situation like this and a matter in the Supreme Court, what happens?
Yeah, what Supreme Court is saying that till the new bill is passed and assented to by the President, the Indian Penal Code of 1860 remains a valid law. So 124 as it stands today is very much the law of the land. In any case, people who have been prosecuted under the Section 124A, they are not going to be affected by any change in the law as and when Bharatiya Nyaya Sanhita is approved by both houses of parliament and signed by the President. And therefore, the whole question of that law, they say, and its constitutionality is to be examined. I think it was somewhere on the back of the mind of the Supreme Court that though what sedition may not be there in Bharatiya Nyaya Sanhita, but this new offense talking about sovereignty and integrity of the country and secession is very much there. So you do have the old wine in new bottle and with much severe consequences. If you look at sedition of 124A, the punishment was 3 years. And here we are talking of 7 years punishment. And we have also included even the financial matters within sedition. So again, my whole, problem with the law of sedition has been that if anybody does anything against the country, then of course that person must pay the consequences. But country and government today in a democratic polity are not one and same. So state and governments differ. So the criticism of government is not to be equated with the criticism of India or Bharat, whichever word you want to take. For me as a constitutional law teacher, both are equally important and equally acceptable. So if somebody is going against the state or against my country, for instance, then I must necessarily punish. Now, there are provisions already in the Indian Penal Code, and those provisions have been retained in the Bharatiya Nyaya Sanhita, waging war against government of India, or abating waging of war against government of India, or inciting waging of war against government of India. And there the punishment in Section 145 is life imprisonment. Similarly, to do a conspiracy to wage a war against government of India, you may not succeed in your conspiracy. And as you know, for law of conspiracy, mere agreement between the two people is enough. You have 10 years punishment. Then if you are collecting arms and ammunitions against our country, then also you are going to be punished. Similarly, if you are trying to ensure a revolt in the army or in the navy or in the air force, then again you have 157 to 166 sections which deal with all kinds of desertions in army, revolt in army. So my feeling is that as far as national interests are concerned, they are fully taken care of by other provisions. And in a modern, liberal, democratic state, mere words should not, make somebody punishable. And that's why I'm against criminal defamation, and I'm also against blasphemy, because I believe that in modern, liberal, democratic state, a defamation of religion should have no place. So the whole idea is that this offense of sedition, as you know, it was not there even in the original penal code. And today, Chief Justice of India noted, shockingly, that it was not made a cognizable offense till 1973. So even colonial masters did not treat sedition such a serious matter. And it was introduced as 124A when the ulema of Deoband issued a fatwa to wage war against the Britishers, the fatwa of jihad against the British. So now this fatwa is merely words, nothing coupled with it. And for that there was no crime. That's why sedition came in. Now with freedom of speech and expression and fundamental rights being
I understand the point that you're making,
India,
Professor Mustafa.
And when you governments are replaced in a democratic process, criticism of government...
Yeah, which is why, you know, one question that I wanted to ask you, Professor Mustafa, hypothetically speaking, if the Supreme Court, you know, comes up with a judgment, which it will eventually, on sedition, as we know, as of this moment, that is 124A, and meanwhile, the government goes ahead with its proposal of scrapping 124A and replaces it with its proposed provision, section 150 of the Bharatiya Nyaya Sanhita, what will be the relevance of a Supreme Court judgment vis-a-vis 124A or vis-a-vis sedition? Because it would have already been scrapped.
No, Parliament's power to legislate as a sovereign legislature is not limited by any Supreme Court judgment. Parliament also has the right to overrule the Supreme Court judgments. There have been hundreds of cases where Parliament has done that, but we remember only Shahban for obvious reasons. So, whatever Supreme Court may say, Parliament is not going to be affected by that. Once the new court comes in, then Supreme Court again will have the right to examine its constitutionality. And their Parliament cannot stop Supreme Court from pronouncing a judgment on the constitutionality. So these are two entirely distinct processes of two different institutions. Parliament is supreme to make whatever law or crimes they want to provide in the new bill, and Supreme Court would be free to examine their constitutionality. What is happening in the Supreme Court, I don't see that this bench will be constituted before Parliament passes the new bill. In all likelihood, in the winter session, or maybe from September 18 to 22, I don't think the Select Committee is going to quickly give that recommendation. But these three bills are likely to be passed, and eventually the bench which is examining the constitutionality of sedition would be called upon to examine the constitutionality of new section 150, which, for instance, subversive activity we have included in it. We have not defined subversive activity. It is good that we are talking of secession now and sovereignty and integrity now, but we have really widened the ambit of offense of sedition under the new code. And therefore, the change is cosmetic. Nothing much is there. To say that sedition has been repealed is not the accurate statement.
All right. Professor, thank you very much for joining us, Professor Faizan Mustafa. We've reached the end of this program.